appeal in the matter of the Queen on the application of Aviva Insurance Limited and another, and the Secretary of State for Work and Pensions.
May it please the Court,
Yes,
my Lady Brown and McGurk for the Secretary of State for Work
Yes.
and Pensions.
Before you get going, can we just talk about logistics, sitting logistics? The first thing is that we need to rise this afternoon by about 4:10.
Yes.
Can't sit any later than that because I have to attend a swearing in the main building. Tomorrow night, neither Lady Justice Carr nor I can sit much beyond 3 o'clock, so I think we need to break at 3. If we run into a third day, we can't start till the afternoon because Lady Justice Carr has other commitments. So if at any point you think that, and I also to add to that I can't sit beyond 4:10 on Thursday either. In fact, probably 4 o'clock is the limit. So if at the end of today either of you think that an extra half hour might be needed, then perhaps we could sit at 10 tomorrow morning.
My Lord, thank
Let's
you.
see how we go.
Noted and understood. The listing is, as we understand it, 2.5 days. We've agreed a timetable between us which envisages using 2.5 days, and we hope that that will be sufficient. It should be. We've offered the Court some reading, which we anticipate will have been done.
We've done that.
The Court's very kindly given us permission for a skeleton argument of 45 pages, which allows me not necessarily to go into a lot of the historic detail in as much detail as might otherwise be necessary. So a lot of that we will take as read. That said, there's quite a few points in respect of all 8 grounds and of course the insurer's cross appeal that we'll be traversing over the course of the next 3 days. My Lord, in terms of introductions, Mr. Kent, Queen's Counsel, Mr. Tankle and Ms. Boakes for Aviva Insurance Limited and Swiss Reinsurance Company Limited. The Court has core bundle, supplemental bundle and authorities bundles. And I regret to announce that I have 2 more authorities, which I have put on the bench.
Yes.
And I'll make reference to those in due course. And the insurers have very kindly brought a replacement of the 1948 Act, because in fact the version in the bundle did not contain legislation in force at the time. So that falls to be replaced if the Court is using paper copies.
That's tab 3 of 81.
Yes, my lady. In broad terms, the timetable is straightforward. I'll open on all 8 grounds and deal with, effectively, the insurer's complaints on their cross-appeal.
Ms. Brown, I don't seem to have the 1948 replacement bit. I've only got one. These 2.
Kent is going to
another couple here.
So, do you want to show?
if you would be kind enough, we've got some additional copies here.
Sorry, it got put underneath someone else.
Right.
The batting order is my appeal, Mr. Kent's response and his cross-appeal, my reply, and then Mr. Kent has claimed the last word on his cross-appeal, albeit limited.
Okay.
In terms of what we're proposing to do, I'm going to take the Court straight to the issues in the appeal by reference to the scheme and the situations, and the Court will understand the terminology that we're using. That will take a reasonable period of time, but then after that I'll be able to make hopefully quicker progress in terms of identifying what we say are the errors in the judgment. So that will be the second part of my submissions. And then, connected to that, the third part, I will go through the grounds. And of course, ground 1 is at the heart of all of this. But grounds 2 to 8 are important and indeed do raise important points of constitutional principle as well. What I'm proposing to do is to start with the order. The appeal is against the order of Mr. Justice Henshaw, which is behind tab 20. Does the Court have tabs?
Yeah.
Page 252.
Yeah.
So the Court on the claim for judicial review made an order dated the 25th of January 2021 and made a declaration which appears on page 253, which requires some unpacking, which I will do in a moment. And then made various further additional orders following on from its declaration. So, if I may, just taking then the components of the declaration, where Aviva, the first claimant, became primarily liable under a policy of insurance issued before 19th of March 1997, which is the enactment date of the Social Security Recovery of Benefits Act 1997.
Enactment or entry into force?
Enactment, my lord. So
Yeah.
the commencement date is 6th of October of the same year.
Thank you.
To indemnify its insured in respect of liability to pay damages for a disease. So that is any disease, not merely mesothelioma or asbestosis, but does not include, and one will see this in the statute in a moment, injury.
Doesn't include injury, but includes all disease.
Yes.
Yeah.
Then the order records that my client has acted unlawfully from the dates stated below, and I'll deal with the dates separately, because she failed to read down provisions of the Act as required by Section 3 of the Human Rights Act, or to make regulations under Section 22, subsection 4 of the 1997 Act. Again, there's a separate issue which we'll come on to in due course in respect of that.
Yeah.
So as to permit, so not mandate, but permit a reduction of benefits, or a reduction in the quantum of benefits paid or likely to be paid during the relevant period to be recovered.
Sorry, do you say there's significance to the fact it's permit, not mandate?
Yes.
Right, okay, thank you.
To be recovered under Section 6 of the said 1997 Act. And I'll explain to the court, of course, what Section 6 does. From the insurers as the maker of a compensation payment in respect of such disease. And then the court lists certain situations, but three very short points before I come on to the situations. The first is a point I've just made to my lady. It says require, not it says permit and not require. And one would think that on the insurer's true case, it should say require. That's the first point. The second point is that the court does not say in here what the reduction in liability in fact should be, but it is perhaps implicit from this order that it should be a so-called matching reduction, as the insurers put it, and I'll come on to the matching concept in a moment.
Just on that, is there anywhere a general schedule of damages so that we could work out what the Chancery Division will be looking at?
No, there's no schedule of damages, either in respect...
Or an outline of how they would put their case?
There's an outline of how they would put their case in respect of Mr. Bainbridge, albeit even that is not properly scheduled, because we don't know, for example, whether there was any contribution in Mr. Bainbridge's case. One of the points that I'll make in due course is that there's no defence filed in that particular claim. So we don't know if a contributory negligence point was in fact taken and how that would fall to be applied.
There was a settlement, wasn't there, in Bainbridge?
Yes, indeed. As there often is in complex personal
Yeah, I
injury.
understand
Yes.
that, but I mean, in a sense, this is your point.
Yes. That's it, precisely my point, my lord. So
if you look at contrib, for example, it's all very well if you've got a case in which it's pleaded out and or if there were, for example, if it had gone to trial and the judge had found
yes,
that the claimant was 25% contributory negligent.
yes,
But in a lot of cases, it's alleged by the defendants that the claimant was contributory negligent. Sometimes they'll put a figure on it, usually somewhere near 100%, which doesn't bear any relation to what's likely to be found by the court in due course. And the thing's then settled.
absolutely.
So you don't actually know what the figure either was or would have been.
Yes, Mr Bainbridge issued his claim in the Queen's Bench division. Had that gone to trial, a High Court judge would have analysed that question by reference to principles of law and made a determination. This scheme involves a decision maker in the Department of Work and Pensions providing a certificate with a schedule, and that's it. The decision maker can't put himself in the shoes of a High Court judge and determine contribution, which is one of our very many complaints in respect of how the so-called matching scheme is supposed to operate.
Wasn't that a hot topic of debate in 1996, the extent to which there would ever be a breakdown of how a particular settlement figure was reached?
Well, my lady, the description of hot topic is problematic. There was discussion.
Yes.
And one of other complaints in respect of the judge is that he appears to have taken the view that the adequacy of the discussion and whether it was in fact a hot topic, as my lady puts it, is a relevant factor to take into the balance. We know that it was considered and discussed by Parliament. The extent of their scrutiny and the intensity of it is something which I say is actually irrelevant when one considers the Supreme Court judgment in SC, and in any event has led this judge astray, because this judge has basically used Hansard as a way of trying to understand what the 1997 lawmakers were really up to here, whereas he shouldn't have. He should have directed his attention to the statute and to my case as to why the measure was justified in 2021, notwithstanding the common law developments since 1997.
Yeah.
That's the heart of it.
So that's the
Yes.
point about matching.
So that's a point about matching. So then the final point just to note here, and this is a point which I'll come back to, is the court has referred section 22.4 back to section 6. So the court appears to take the view that there is vives under section 22.4 to cut down what I would describe as the primary liability of the insurer under the statute, which arises by reference to section 6. Now, the court may have seen, and just to summarise, the statute interferes with property rights in two ways. The first is that it establishes a freestanding liability to the state to repay the benefits, and that's a liability that's imposed on tortfeasors and insurers. So that applies as between wrongdoers and insurers and the state. That's section 6. The second way in which it interferes with property rights is that it also interferes with the bargain that's been struck between the insurer and the insured, and under the policy of insurance. That's section 22, not section 6. And what that provides is that under the contract of insurance, there is also a liability to the insured. And I'll make a number of points about that, but it's perfectly clear that what Parliament was doing was targeting the insurers as the primary paying entity by reference to this measure. And we say it was entitled to do that.
Well, he's inevitably doing that because employers' liability insurance had been compulsory since 1972.
Yes.
And a number of employers had gone out of business in the meantime.
They have, but a number have.
Looking at the insurers.
Yes, but a number haven't. And what this judgment does, and this order does, is create an inexplicable difference in treatment when one has regard to the scheme, because nobody is suggesting that tortfeasors are not liable for the full amount, irrespective of matching. That liability arises under section 6, and that's a direct liability from tortfeasors to the state. So whatever the insurers have accomplished in this litigation, my client can pursue the tortfeasors for the full amount of the recoverable benefits, because nothing in the judgment prevents that.
And the tortfeasors can't recover from their insurers for the...
Well, query. At the moment, under section 22,
question.
a so-called insuring clause has been inserted in the policy, so they can recover from the insurer. The issue then is, well, what about the fact that the Secretary of State hasn't removed that through regulations under section 22.5, so section 24, and what does that do to the bargain between the insured and the insurer?
Yeah.
So we do have a situation where we say that, in fact, this is potentially all going round in circles, because if they're right about Mr Bainbridge and all the other financial liabilities, those are liabilities that my client will then look to the tortfeasors for, not the liability insurance industry. They will then potentially recover those from the insurance industry under the insuring clause, and it potentially or starts to go around in circles. I don't know. But the short point is that we are now already very far away from what Parliament was looking to do with this legislation, as expressed in its very clear statutory language. The three situations are then addressed in the order, so just dealing with those. The first then is contrib. And the reference to proportion only of the damages otherwise due is, of course, common law damages. So the so-called matching scheme that the insurers promote is based upon there being an analogy between the statutory liability and common law calculation of damages. It has to match, they say, in order to be compliant with A1P1. And that's why we see repeated references to damages. So that's the first one. The second one.
Sorry to interrupt just before you leave that, but just for my note. In Bainbridge, there would have been pre-action protocol and correspondence. Did that raise the issue of contrib?
We don't know. We don't have that. All we have in terms of...
It's not in I couldn't find it in the supplementary bundles, but it's not being disclosed as part of this before the judge.
No, because this is all being done on effectively pure principles.
I appreciate that,
yes.
but there was a test case for
Yes.
Bainbridge, so one would have expected to see at least a pre-action protocol correspondence.
Yes, no, we don't have that. Not
Perhaps the parties can get it to us.
Yes, my lord. It will sit with that side of the room because this is all as between them and.
Look, if it helps, we weren't putting forward Bainbridge as an example of contributory negligence, but simply an example of a case where the benefit was in respect of no head of loss that was claimed, no loss of earnings.
But if Bainbridge was a contributory negligence case, it would be helpful to know. Okay. So that's one, Mr. Brown.
Yes, so that's one. Then two is damages for a divisible disease, and asbestosis is a good example of a divisible disease. And my lord will appreciate that on the common law authorities, every exposure to asbestos is capable of contributing to the disease. And what the House of Lords and Supreme Court have done is effectively fashion common law principles that do not require causation to be proven on the balance of probability. So see Fairchild, and the summary which is in McGregor behind authorities Camp 56. And I'm not proposing to take the court through all of that very interesting developments in the law. We accept that that's how the common law has developed, but that's simply just a matter of fact. And what that means in terms of a matching scheme is that the court's response to this is that there has to be a pro rata reduction in the statutory liability to repay benefits to match pro rata what the tortfeasor's liability is to its victim following the decision in Barker and Chorus. And in Barker and Chorus, it effectively prorates liability by reference to a temporal split. Yes.
And there's been no equivalent in England and Wales of the Scottish Act in relation to Barker and Chorus?
No. So on the facts of this case, carrying out the calculation, the liability of Aviva to Mr. Bainbridge would be 35.3% if he had asbestosis. He has mesothelioma, but if it were asbestosis, it would be 35.3%. And I'll explain why shortly. In situation 3 is the same approach for an indivisible injury such as mesothelioma as to divisible injuries. So here, the notional correspondence is to the 35.3% aliquot share. That follows Barker, but it necessarily ignores the fact that Parliament has reversed the common law by Section 3 of the Compensation Act of 2006.
So this contemplates, does it, a situation where the tortfeasor is liable in full because of the Act,
Yes.
but the the insurer is only liable for 35.3% in your example.
Well, we don't know what is contemplated in terms of the tortfeasor, but assuming that that is right, that no complaint is made about the tortfeasor being liable both for 100% of common law damages and 100% of benefits, then my lord is absolutely right. That contemplates then that the insurer is liable for 100% of damages, because that's what section 3 says.
Okay, got you. 35.3%.
But 35.3% on this scheme, because it has to follow in every respect the common law.
Well, there's some shaking of heads on the other side behind you, which you can't see, but that's why it would have been helpful to have schedules at least of how this was all meant to work. Anyway, okay.
Well, I'm not sure what the shaking is referring to. I mean, that is the transparent effect of what they say. But anyway, well, Mr. Kemp will enlighten us all in due course. Note the dates, please, because another point and another complaint is that the insurers have founded their claim on what they describe as increasingly onerous costs that they meet following the developments in the common law. So starting with Fairchild, Barker, Compensation Act, etc. Now that would appear to suggest that there has become a tipping point of some sort when the costs have just become so burdensome that what was compliant with A1P1 has ceased to be compliant. Now,
Can you just remind me, it's my fault, but what were the competing arguments? I mean, the consequentials were obviously complex.
yes.
What were the competing arguments for dates? What were you saying the dates should be?
Well, a number of arguments, but a fundamental position is that it is now that because it's the date of the claim form effectively, because if the insurers are coming along and saying the burden has now become so much we can no longer reasonably shoulder it, then it's the date that they...
Right, so you were saying date of the claim form.
Yes.
And because the claimants were saying that as we come into in ground one that the relevant dates are the dates of each payment, but did they then argue that October 2000 was nevertheless the correct date?
Yes. So when we got to the consequentials, they say, well, true it is, we're using Mr. Bainbridge and the liability that arose in 2019, but actually our real complaint goes all the way back to the commencement of the Human Rights Act, because Parliament should never have done this in the first place. It should have anticipated somehow what would happen in the common law, and it should never have allowed a situation to be legislated which meant that there was additional liabilities, as they put it. So liabilities beyond the common law, damages, correspondence.
So is the working of this order, as you understand it, that if there is a payment in 2001 under a compensation recovery certificate, that is sent off to the Chancery Division?
That is how I understand that they are going to formulate their case. They've described it as a...
And what happens on limitation in relation to
I was
that?
going to say, why isn't that claim time barred? Why isn't every claim time barred, which is more than a year before in the claim form?
I've got a ground of appeal on limitation,
Yeah.
but I've also reserved my...
I don't think it needs to go to the Chancery Division for that, really.
Well, my lord, I agree, of course, but they say...
Anyway, here we are.
Well, very briefly, the argument is that actually this isn't a claim for just satisfaction. This is a Kleinwort-Benson claim for restitution at common law on the basis of monies unlawfully levied. There has never been such a claim under the Human Rights Act for good reason. It's a different regime. And the reason why the claimants, the insurers, were so anxious to get a declaration that my client has acted unlawfully, as opposed to simply a declaration as to what the rights are under the convention, is that they say, and I disagree, that founds a Kleinwort-Benson restitutionary claim on the basis of monies unlawfully levied. That's their argument. So that they are claiming, and will be claiming in the Chancery Division, repayment by way of restitution of the whole lot, everything that the state has paid out since the 2nd of October 2000. Sorry, everything the state has taken it.
Subject to the point of principle, on the back of this declaration, that's a slam dunk.
What
I mean,
is
sorry, so it's subject to whether or not restitutionary claims are permitted, and you say
Yes.
not. Does this declaration does it permit of a limitation argument still
Yes.
to be raised?
The limitation is expressly stood over.
Sorry.
So
Yes.
The limitation is part of what the court would have to decide later.
yes, there's two lots of limitation in play here. The first is, well, you should have brought this claim many years ago. That's the ground of appeal before this court.
Yes.
And the second is the Ordinary Limitation Act and we say Human Rights Act limitation points, which would apply to any financial claim too. And those have expressly been stood over to the Chancery Division because we say, of course, this is all subject to limitation. But we will have an argument. They are claiming restitution and no doubt with some form of interest. So that is a complaint which we will come on to. We say, well, it's not even consistent with the insurer's argument about tipping the burden over the edge to then say that actually the illegality arises ab initio. That's effectively ground 7.
Well, the mismatch arose ab initio, didn't it?
Yes, the mismatch is hardwired into the statute, as we will see in a moment. So that is there from the outset of the 97 Act. Human rights are brought home on the 2nd of October 2000. So there's then a justiciable complaint subject to arguments that we'll have later. And I accept in principle that the sort of argument which could be that, well, what Parliament thought might be appropriate in 1997, the situation has now changed so dramatically that it's right to look at the position now, and indeed you should look at the position now, and that would found a claim. But that's not what the court's done. It's effectively said that you cannot ever introduce a scheme that is not a matching scheme. Just in terms of what the third commencement date is, 1st of January 2003. So that's not the commencement date of the Human Rights Act, that is a few months after Fairchild. The logic of the court being that once the House of Lords has handed down Fairchild, Parliament or my client should have appreciated that the legislation on the statute book had ceased to be compliant with A1, P1, and they had a few months to sort it out, but didn't. We then have the consequential orders, and we've touched on these. So, point about quashing of the certificate. So, effectively quashing all of the certificates which found the statutory liability, which would prevent, therefore, my client from recovering the sum. So, that is a serious consequence, of course. And then the damages and the restitutionary claims. So all of that has been transferred, and then the court granting PTA at paragraphs 4 and 5. And paragraph 5, the cross appeal, is to the effect that situations 1, 2 and 3 don't go far enough because there's more mismatches with the common law. The situations 4 and 5, situation 4 is a cross appeal, and situation 5 is not a cross appeal, on the basis that they say, well, it does mismatch, but we'll live with it. And that's their argument on that.
So where is the bit about limitation in this order?
That's why.
Yeah, it's not in the order.
Well, there haven't been any damages claims yet for us to raise the argument on limitation on
Yeah,
yet.
but you've
You
lost.
raised it here.
You've lost in front of the judge who's transferred it over. How can you raise limitation as a defence?
Well, because there's no claims, there's no financial claims that have been advanced yet. So I accept, my lord, and certainly the position of the parties, which the judge has accepted, and we'll look at this in supplemental judgment, is that limitation is critical, and it goes to the financial claims. There are no common law financial claims even contemplated. There's no letter before claim in respect of those, so we've lost the judicial review. But the way that the parties have very sensibly approached the financial claims is that they are essentially freestanding, certainly insofar as their common law restitutionary claims. So I take my lord's point, but we would say, certainly in response, that the parties know, and the judge...
I mean, it's only on paragraph 2. It just says claimant's claims for damages which were made in this action and or a restitutionary remedy, which rather suggests the judge has permitted some sort of amendment. It's not starting new actions that have been transferred, it's this claim that's been transferred.
Yes, but
I mean, it might be said, well, you know, if you've not claimed and particularised your damages, fine, but in fact you'd all agreed that it goes to the Chancery Division. But I mean, what has been agreed to go to the Chancery Division isn't clear at all.
But I said that all of the points of principle, including limitation, were proper to the administrative court. And the judge in the supplemental judgment said, no, even those can be transferred to the Chancery Division.
It may be a point in your favour, Mr. Brown.
Well, in which case I'm grateful.
No, it may be if my lord is right and limitation has been done and dusted here, that may be a point in your favour. I don't know, but it's not, as my lord Justice Dingemans says, it's certainly not clear what the position is on all this.
I'm not sure the judge deals with limitation. I mean, looking at his supplementary judgment, does he actually deal with
He
it?
certainly does not consider that he is prevented on limitation grounds from making the declaration of unlawfulness
No.
as from October 2000 and
And
January 2003.
That's certainly right, and I appeal against that.
Yes.
So this is why I say that there are two species of limitation in play. But perhaps I can deal with that at an appropriate time, appreciating its central importance and significance, as my Lord Justice Dingemans properly points out. It is important. But we have a very substantial primary ground of appeal in respect of A1P,
Yeah.
which might be helpful to...
Well, if you're right about that, then everything else falls away. So,
Yes, it does.
yeah.
So what I'm proposing to do now then is to show the court the scheme, i.e. the statute,
Yeah.
and that is behind tab 6 of the authorities bundle. This is the Social Security Recovery Benefits Act 1997. It is an act that applies to all parts of the United Kingdom, in contrast to English common law. This replaces the legislation at tabs 4 and 5 of the bundle, the 1948 Act, which was a fairly crude initial scheme, post-Beveridge, for resolving or changing the balance. And then the 1989 scheme, which was a far-reaching compensation recovery scheme, which established the compensation recovery unit and established the liability to repay to the state social security benefits. Now, just in terms of legislative history, what one sees then is that Parliament changed its mind after the 1989 Act, indeed fairly swiftly after the 1989 Act, because it was of the view that the social injustice subsequent to that Act warranted reform. And one of the points that the judge thought significant, as we'll see, is that the judge considered that the mischief targeted by the 1997 Act was limited because it was responsive to issues that arose following 1989 in terms of small payments and set off against pain and suffering, and I'll expand on that in a moment. But what the judge failed to appreciate is that this is actually a complete restatement of the existing scheme. So true it is, it targets two particular defects, but it also goes much further than that, because it restates what Parliament thinks is appropriate in terms of a wholly novel statutory scheme which provides for the recovery of social security from tortfeasors and insurers. So a significant intervention that dates back to 1989 at the very least in the marketplace, which introduces something which had not been done before, which is establish a statutory liability, so a quasi tort, as it might be described, but certainly a statutory responsibility on the part of tortfeasors and insurers to make payments to the state. So it does have to be considered in light of the decisions that were made pre-1989 as well. insofar as relevant. And it is a response to a very long debate about the balance of fairness and the role of social policy as an engine of social change. It's a debate that goes back 70 years to the post-war settlement. There are no right or wrong answers. There are different judgments and decisions about what the response could be and where the balance of fairness should properly be struck. The interests that are being considered and balanced are those of victims, tortfeasors, insurers, and taxpayers. So 4 cohorts who all have an interest in this. And indeed, in addition to the financial interest of taxpayers, the interests of the community at large. So the community interest in using measures such as the recovery of benefits to prompt and nudge change in industry. And there's nothing wrong with that. That's what social policy is. So, my Lord, this is an act on the statute book.
And you say, at heart, where you, as it were, where you balance the scales between those 4 competing cohorts is quintessentially an issue of social policy for the legislature and the executive.
Precisely so. I do not say that it is immune from review. That's not what the jurisprudence says. But that is a matter which has to be considered prominently by the court when considering review, both in terms of the preliminary issue, what level of intensity will it apply, and substantively. This is an Act of Parliament on the statute books today, and that statute is always speaking. In other words, that statute expresses the will of Parliament today and on every day since it was brought into force. The correct interpretation of that legislation is not, in fact, in dispute. So leaving aside section 3, what Parliament intends is agreed between the parties and not controversial. So Parliament intends to do the things which are the subject of complaint, i.e. establish a statutory liability which in no sense is structured by reference to the matching principles as described by the insurers. Unlike the position after 1989, Parliament has expressed no desire to debate or revisit the balance struck in this Act, despite what Fairchild or any other case might have held.
And in circumstances where they did react by section 3.
Indeed. So Parliament knows about Fairchild, and we know that it knows because we can take it for granted. But in any event, section 3 of the 2006 Act is evidence that, in fact, these particular problems, the balance of fairness in light of the common law, have in fact been to Parliament. In terms of background, the court may have noted from the evidence, just as a point of historical note, so the enactment date is the 19th of March 1997, comes into force on the 6th of October 1997, so it was enacted by the Conservative government and brought into force by the Labour government of that year. Section 1 of the Act provides that the Act applies where a person makes a payment, whether on his own behalf or not, to or in respect of any other person in consequence of any accident, injury or disease suffered by the other. That's section 1(1)(a). And 1(1)(b), any listed benefits have been or are likely to be paid to or for the other during the relevant period in respect of the accident, injury or disease. So just unpacking the scheme then. So 1(1)(a) refers to the damages or the compensation received by the victim. And this legislation refers to a person rather than, for example, a tortfeasor. And that is because the Act applies not just to tortfeasors, but to compensators, which is effectively including insurers, and that's made absolutely clear by subsequent provisions. That's 11A, and 11B applies the scheme to any listed benefits. Listed benefits are defined in section 29 as being all the benefits listed in Schedule 2, and we'll come on to Schedule 2 in a moment. And the point is that all benefits listed in Schedule 2 are recoverable by the state under this statute. So Schedule 2 does two things, as I explain in a moment. First of all, it lists out all the benefits which the state will recover, and also it provides for credits and set-offs against heads of damage. And we'll visualise that with Mr. Bainbridge's case in a moment. So the language is broad because the scheme operates on broad brush principles. It simply establishes the target, i.e. the paying entity, the tortfeasor or the insurer, and it defines the obligation by reference to the listed benefits. And section 1(2).
Sorry, it's my fault.
Yes.
Where's the definition of listed benefits?
Section 29.
Thank you, that's fine.
And there's a point here that arises under situation 4 in the cross appeal.
Yes, I see.
The Secretary of State decides the listed benefits in her discretion.
Column 2 of Schedule 2, and if we
Yes,
go to page 146, we can see universal credit.
Yes, we'll come on to that. That's important, so I'll take the court to Schedule 2, explain how it works. Section 1, subsection 2, statute states that the payment in consequence of the injury is a payment made by a person liable to any extent. So there can be no doubt that Parliament does not recognise this concept of excess payment as the insurers have it, namely a payment beyond the pro rata common law match. Because Parliament says if you're liable for anything, then you're liable for the entirety of the social security recovery obligation. That's its intention and its will as set out in section 1, subsection 2.
And the judge tries to sort of brush that under the carpet rather, doesn't he?
He does. Well, the way
Effectively saying, well, it was in the previous statute and it can't amend that in the previous statute.
yes, I complain about what the judge does is to try and do too many things with the intention point, because the principle as a matter of constitutional law is that the intention of Parliament is set out in this statute, and one doesn't go beyond that. What one doesn't do is try and understand what the 1997 lawmakers were up to. That's what the judge has tried to do. He said, well, look at this select committee report. What they were really thinking about doing is limiting it in this particular way, and he explains why that might be. But as Lord Reid explains in SC, that's not how Parliament works, not even primarily. It's not primarily a debating chamber. What might have been in the mind or contemplation of the lawmakers, one doesn't know because they don't provide reasons for their decisions, and in any event is irrelevant. They can intend or contemplate whatever they consider to be appropriate. And the fact that they say one thing in the debates, and in fact they've got a different agenda in the discussions that they're having in the bars of Westminster, is a matter for them. So we say the statute does not adopt the insurers matching scheme, it rejects it. And then there's reference then to particular schemes, so subsection 1(2) that are brought within scope. And the DMPS, diffuse mesothelioma payment scheme, is one. That may or may not have some relevance. That is an example referred to in the Secretary of State's evidence of another way in which the state interferes with contracts in the market by simply just imposing a levy on the liability insurance industry, in that case by reference to market share, to make payments in respect of diffuse mesothelioma. Nothing to do with English tort law, it's just a...
Well, that's an example, I mean, albeit by amendment to the Act.
Yes.
But as you say, it's a living instrument, we look at it now.
Yes.
As it currently stands, it's an example of what we describe as classic absence of matching or mismatching, because the diffuse mesothelioma payment scheme doesn't doesn't deal with matching with the common law at all.
No, and nor does the Motor Insurance Bureau, the way that the liability insurance industry just deals with missing insurers. There's no principle in the convention that one has to have a matching scheme referable to English common law. There's an argument as to why it might be fair. It's one that the insurers make, but it is one with which Parliament is in respectful disagreement. Then subsection 3, still in section 1, makes it clear that it arises following judgment, compromise or anything else. So again, that's a way of making it workable, a macro scheme. You just check, look whether there's a payment obligation. That triggers the statutory liability. Then subsection 4 defines the payments, and the terms recoverable benefit and listed benefit. They're the associated concepts here. So one has the listed benefits in Schedule 2, and they're only recoverable up to a certain amount, as we'll see in a moment. There's a 5-year limit. Section 1A, which has been introduced by amendment, brings into scope another set of benefits that are provided under the new monoconiosis Workers' Compensation Act. And that's relevant because Mr. Bainbridge, in fact, received such a payment. So that's all I need to say about that, and I'll show the court the actual payment shortly. Then section 2, compensation payments to which this act applies. So it applies prospectively to payments, but necessarily those payments will be in respect of liabilities that arose retrospectively. So it's not complete retrospective effect. If it were, Parliament would be saying, not only going forward do we recover the benefits, but we also do it going backwards. Parliament doesn't do that. It's prospective only in that it applies to settlements and orders made after the Act comes into force. But necessarily, those liabilities will arise because of historic torts.
Yeah.
And because it's historic torts, necessarily, they're covered by existing indemnity insurance policies. So it is a limited form of retrospectivity to that extent. And that indeed was the principle under the 1989 Act as well. And one of the points, we say not relevant, but there is a point about the insurers being put on notice prior to 1989, period of time in which they'd be able to adjust for all of this. And section 3 limits the liability under the Act to the relevant period, which is in the main part the period between the claim and the settlement. And section 3, subsection 2 limits it temporally to a maximum of 5 years. So what that means is that not only is there a 5-year limitation, but also when the certificate is honoured and payment is made by the insurer, that also terminates their liability going forward. So the state can't come back for any more, even though the state will continue to make payments to an injured person. So there's a twofold containment there of the financial liability. Why is it 5 years? The court may have seen that there's a footnote in our skeleton argument tracing it back to 1948, and Lord Simon says it's a shot in the dark. So it's a murky compromise reached by the 1948 Parliament, no doubt having regard to representations that were being made by insurers back then, and that has survived now. But what that does do, and the court was wrong to dismiss its importance, because it is important, is that that is a limitation. It's a balance and it's a mitigation, which counts in favour of the insurers. And it's not really an answer to say that in certain mesothelioma cases, the person's already dead, because this judgment isn't limited to meso.
Well, in large numbers of cases of industrial disease, the victims live for a lot longer than 5 years after the first time they claim benefits.
Indeed, medical science is changing. This statute could be on the statute book in 50 years' time, and it could well be the case that the advances mean that even mesothelioma victims have got a longer life expectancy. So it's not a sufficient answer to have a bald assertion from the insurers, which is what we have, that life expectancy is probably less than 5 years. We don't even know what it was for Mr. Bainbridge. We don't know if or when he died. So it's not a significant point, and certainly did not, or should not have had the weight that the court attributed to it.
But it shows that this scheme can't be a matching scheme, because
Yes.
otherwise there's a limitation. Otherwise you could go forward, and it's perfectly easy to follow through what benefits are paid to an individual.
Exactly. There could be an indemnity going forward, and the state keeps providing the certificates forever. Of course, there's then an interaction with the compensation payment and what the principles are as between victim and tortfeasor and how the common law provides for all of that. But my lord is absolutely right. If this were a true matching scheme, there would not be a 5-year limit, because there's no limit of 5 years at common law, and it would not be terminated by payment. So section 4 sets out the mechanics. Don't need to spend too much time on that, but what happens is that the compensator applies for a certificate. In practice, it's the insurer who does it. And the certificate quantifies for a payment obligation and is good for the period of validity. And I will show the court the certificate in Mr. Bainbridge's case, because it's helpful just to visualise the points.
Was it in fact the case that certificates were provided on an annual basis?
They're on a periodic basis, so they state the period of time, and as one will see when we look at the certificate, what it does is set out intervals of time when, if the payment is made on this date, then the corresponding liability is as follows, but if it's made 2 weeks later, then the liability will have increased by a certain amount.
Yeah.
So the insurer can use that and say, well, I'm going to make payment on the 6th of April, and therefore I know that I've got to pay this much, and that's provided for in the certificate, as we'll see.
And the claimant knows they're going to lose X from their payment.
So the claimant, there is then a credit, and I'll come on to the credit and how that works. But section 6, though, is effectively the establishment of the statutory liabilities, the fundamentally important provision. It creates a statutory liability that is challenged, at least the first of the two. And it is very clear, section 6.1, there is a statutory liability on the person who makes a compensation payment in any case is liable to pay to the Secretary of State an amount equal to the total amount of the recoverable benefits. So again, there is no room for ambiguity or doubt as to what Parliament intends. The payer, the compensator, is liable for the amount of the recoverable benefits set out in the certificate. And the insurers do not dispute that that is Parliament's intention, as reflected in section 6. On section 6, the subsections 2 and 3 provide for the timing and the creation of the liability and the payment obligation. They're not important. What is important is that in section 6 there is no regulation-making power. So there is no way in which the Secretary of State, by way of secondary legislation, can cut down what is provided for by section 6.1. Can't be done. Section 7 deals with recovery. We don't need to worry about that. Section 8 is the credit system. So this is the right of deduction or credit against sums paid to an injured employee under certain heads of claim. And what Section 8 is doing is giving effect in a rough and ready way to the principle dating back to Beveridge of a victim's needs only being met once. So if one receives compensation and benefits, there has to be a way of preventing the individual from being paid twice. That's never going to be perfect. This has to operate on broad brush principles. And we'll see in a moment how that operates to Mr. Bainbridge. Now, the way this works then, by reference to the reduction, is to provide for a notionally corresponding or notional correspondence between the heads of claim and the listed benefits, which one sees in Schedule 2 on page 146. If I can invite the court to have a look at that. So the way that Schedule 2 works is that on the left-hand side, it lists 3 categories of heads of loss, which might be claimed by a claimant in a civil claim. And then on the right, it lists benefits which will give rise to a credit by reference to those heads of loss. So benefit relates to the head of compensation. It has to be either category 1, 2 or 3. And it doesn't matter whether in fact the individual is claiming that particular heads of loss for the purpose of the obligation in the second column. So whatever the claimant is claiming, the liability of the paying party, the compensator to the state, is to repay all of the benefits in the right-hand column. But if they are claiming, as they will typically, perhaps inevitably do in a personal injury claim, one or more of the heads of compensation in the left, then a credit to the benefit of the insurer is applied to the damages award. We'll see this by reference to Mr. Bainbridge. I keep promising the court, but it's helpful just to look at the framework of the Act and then go to...
He didn't, in fact, have a claim for loss of earnings because he was retired,
Correct.
but he was still paid disability pension,
Yes, so...
IDB. But he also had a claim, I think, for cost of care. So
Yes.
there'd be a claim for attendance allowance, and the attendance allowance would be reduced. Sorry, the amount of the attendance allowance would reduce his damages for the cost of care,
That's absolutely right.
but not his damages for loss of earnings. He didn't have any.
No, he didn't have any. Didn't bring in any particular claim because on his factual circumstances he happened to be 77 and retired, so he doesn't have any lost earnings. That's not inevitably the case. Might often be the case in an industrial injury, but it's not inevitable. But the intention of Parliament is perfectly clear, irrespective of whether an individual's brought a claim under Section Part 1, the benefit under 2 is repayable. And there is a logic in the benefits that are set out in the second column of the schedule. They're not all there randomly.
There is some matching here.
Yes, there is a broad correspondence because what Beveridge said is that the prompt maintenance of income is of the essence of social security. So what one sees in the first part is that, broadly speaking, those benefits are related to the maintenance of income. Not all, because it could be said that disablement pension is more like deferred earnings because it's more like a form of pension. In fact, it's a very prescriptive benefit that applies when somebody has a workplace injury, effectively. So even the word pension there is slightly misleading because that, like all of the other benefits, is in truth. They are all in truth benefits which in broad terms are designed to maintain income. So it's a form of replacement income provided by the social security system.
So that was exactly what was contemplated by Beveridge, wasn't it? That
Yes.
The individual victim would be, in the first instance, would be funded by the state until such time as the tortfeasor and or more likely its insurer
Yes.
agreed to pay out, at which time you then have the obligation to pay to repay the state.
Absolutely so, my lord. Yes. So that's the logic for those benefits. One doesn't see, for example, child benefit in there because child benefit doesn't in any sense serve that purpose. So the Secretary of State making a rational decision as to which benefits to list would probably not consider it appropriate to list those other sorts of benefits because what she has in mind, clearly, is income replacement. The specific complaint in relation to universal credit is that universal credit itself with far-reaching reform and actually brings in aspects of what are described as legacy benefits that go further than income replacement, which is true.
But again, there was a sort of a change to the legislation to refer to universal credit,
Yes,
but no other change to the structure.
absolutely so, my lady. So the Secretary of State, knowing that universal credit is now replacing 6 legacy benefits, has a decision. She has to decide, should I list that in the first part of Schedule 2, knowing as I do that that is also primarily an income replacement benefit, or should I not list it, knowing that that disadvantages the state and is probably contrary to what the scheme is really intended to do, because there's a mismatch, because it goes a bit further than income replacement, because it draws in other sums which might be attributable to things like housing need. And the insurers, we say, would have to actually challenge that decision. They have got to say that the Secretary of State has acted irrationally in listing universal credit insofar as that's their challenge under their cross appeal. And they can't come anywhere close to doing that. So just identifying the benefits for Mr. Bainbridge, and I appreciate the court has already done that, but they are disablement pension payable under Section 103 of the Social Security Contributions and Benefits Act 1992. That's the first one. The second is attendance allowance, which one sees at the bottom of the page, which is in the second group. And then the third benefit that relates to him is the lump sum pneumoconiosis payment made under Section 1A, which is dealt with by way of the insertion of that scheme within the framework of the Act. So those are the 3.
Sorry, where's the third one?
Well, the third one is a payment made under Section 1, the scheme that's introduced under Section 1A. So it's a lump sum pneumoconiosis payment. So legislation brought in I think it's 2006 or thereabouts, I'll correct that, which provides basically for lump sum payments if you have suffered the disease and it's referable to the workplace.
And of course, Beveridge's original aim of ensuring that claimants then weren't overcompensated is also affected by the fact that you can set up personal injury trusts, which enable in some circumstances, benefits to continue to be paid, even though the insurers have compensated fully for the lost earnings they've caused.
Exactly, there's that, and then one gets into all of the Parry and Cleaver type arguments about where does all that fit within the framework of the common law, in terms of what you bring into account, in terms of quasi-insurance, etc. And these are all complex, difficult questions. Section 17, very briefly, that abolishes then the common law principle that the listed social security payments are brought into account. So that responds to the fact that, see cases such as Hodgson and Trapp, the court's basically deciding almost on a case-by-case basis what's the purpose of the benefit and should it be set off against the damages award. Parliament has swept all of that away in terms of the listed benefits. They are only dealt with under the schemes of the Act in terms of set off from compensation awards. Anything not covered by the Act is subject then to common law, but we're not concerned with any of those. And Section 18 provides for authority in the Secretary of State to deal with complex cases. Sorry, Section 18, yes, lump sum periodical payments. And Section 19 confers the power to deal with the situation when you've got multiple compensators. What in fact has happened is that the insurance industry has sorted this out amongst themselves. So they have an agreed protocol as to how they deal with these liabilities. And Section 22 is the next port of call. So this is the second limb of the challenge, because this interferes with the position as it pertains between insurers and insured. this is important in the following respects. The first is that it imposes, by way of section 22(1), a contractual obligation between the insurer and the tortfeasor. So the insurer is liable to the state, and for the avoidance of doubt, the insurer is also liable to the insured as a matter of contract. That is clear then from sections 22(1), 2 and 3. And section 22(4), we saw in the order, this founds part of the conclusion on remedy, namely that there is a power conferred on the Secretary of State in prescribed cases to limit the amount of the liability imposed on the insurer by subsection 1. Now, there are no such regulations, but we challenge the conclusion that section 22(4) provides any virees to reduce the liability of the insurer under the state at all. That's the first part. But also, on application of the Padfield principle, we challenge the conclusion that the Secretary of State can, or indeed is compelled, to do something which is so transparently contrary.
What do you say section 22(4) is designed to cover?
Now, there is some reference to this in the judgment, and I will come on to it. I'm afraid I don't have that answer at my fingertips, although I've noted it, but it is probably limited in scope, in the sense that, well, for the first point is it's only looking at the position as between the insurer and the insured.
Yeah, sure.
My main point is it is not saying anything about the liability of the insurer to the state. So it can't be.
Well, what it does do, it prevents the insurer is still liable to the state, but by not enacting the regulations, it prevents the insurer from making any claim back against its insured, whose original negligent conduct it had agreed to insure under certain bases, but which was extended by 22(1).
That would be one consequence, yes.
And assuming that the insured was still in existence.
Yes, and there's an interesting question. I don't know what the answer is, but what happens then if there's insolvency and there's established liabilities then? And what happens in terms of issues of transfer? But we don't need to go down that route, because our primary complaint is twofold. First of all, it has no purchase on section 6. It can't do anything in terms of section 6, contrary to what the court has held. And secondly, and fundamentally, one has to have regard to Padfield. What is the policy objective that the primary legislation is promoting? Because the Secretary of State can't adopt secondary legislation which cuts down the purpose of the Act. So if, in circumstances where it's common ground that the purpose of the Act is as set out in section 6, namely it does bite on additional liabilities, how is the Secretary of State empowered then to do something so directly contrary to the Act? She can't.
Going back to your first point, I know you'll expand this, but if you look at subsection 4, it clearly refers explicitly to affecting the liability imposed on the insurer by subsection 1, which is the
Yes.
contractual liability, not the liability to the state.
Yes, that is right. Then section 22(5), because I haven't really said very much about retrospectivity, it's possible that this case is only about retrospectivity if one considers the way that the arguments are now presented. Insofar as retrospectivity is relevant here, Parliament has expressed its intention in section 22(5) that it does apply retrospectively to policies issued before as well as those after it coming into force. So we say that is an insurmountable barrier in terms of primary legislation. Because if the complaint is, as one sees in the order, that it's about policies post-dating the Act, which need to be, which are fine, and those predating have to be carved out, that can't be done, because section 22(5) expresses Parliament's intention that all policies are to be brought into scope. Why? Because that's the only way in which the scheme's going to work.
So why?
Well, because if one's looking for a scheme which establishes a liability for compensation in respect of things that have already happened, so injuries that have already practically taken place, then insofar as that there is going to be recovery from the liability insurance industry, that's going to be a liability that's covered by existing policies. So Parliament is consciously directing its attention to recovery of all benefit payments that have been made, triggered by a payment that is made going forward only. Well, I accept entirely that one can have a different scheme which isn't retrospective. So one can say, well, we're just going to suffer the losses going forward. That's fine. But it can't be said that that is the intention of this scheme when one has regard to sections 1, 6 and 22. So again, one is back with the issue of, well, look at Parliament's intention as disclosed by the statute. That is clear.
Yeah.
Was that the intention of the 1997 lawmakers? We say irrelevant, but in any event, it's actually clear when one looks at Hansard that they knew what they were doing. So that's the second part. And then the third part is, well, A1P, where one and do contracts of insurance have such a sacrosanct position under the convention that they can never be the subject of interference? And I'll make separate submissions about all of that. In section 24, that empowers the Secretary of State then to amend Schedule 2, as she has done when bringing in universal credit. Yeah. In section 30, the regulations being subject to annulment. So that's the section 6.6 Human Rights Act point, which we'll deal with later. So drawing the strands together and the risk of repetition, the statutory scheme is not based in any sense on common law principles of assessment of damages. So Parliament has gone down a completely different route. First point. Second point is that this is intentionally a broad brush scheme. Certificates are calculated in a straightforward fashion. It's not case specific. There's no notional district judge or high court judge thinking about facts before him or her and deciding what the position might be by reference to the common law. It's a macro scheme operating at a macro level. There's no discretionary judgment whatsoever in the scheme. And because it's broad brush, there are broad brush compromises. That is the nature of it. 5-year scheme, termination of liability on payment. And then there's a third point here, or an additional point about what I might describe as the swings and roundabouts nature of the scheme. And this is the missing insurer type situation. So the insurers say that you've got to prorate it to our period of coverage, and we're not responsible for the period where we are not covered. Secretary of State says, well, you're responsible for the whole lot. That's a scheme. What then of the position when there is no identifiable insurer because no one can find the responsive policy? There were lots of those cases because we're talking about historic schemes. In those circumstances, the state pays, the state bears the burden because nobody has been identified who is liable in respect of a payment. So in that situation, so missing insurers, for want of a better expression, the liability insurance industry doesn't pay, so contrast the motor insurance bureau type scheme where it's precisely directed at that. And instead one has a scheme whereby the state picks it up. The insurers say, well, that's a bit tough. Look at Carr, case which Mr. Kent did, where in fact the aliquot liability was only 2.3% of the overall amount. Mm-hmm. But the insurer's sitting with a liability for 100%. That might be a tough individual case, true, but it's a macro scheme. So Aviva, or whoever it is identified as the insurer in that particular case, and they pick up the balance. There's a 98% missing insurer, but that means somebody's had the premium because of the amount of time that EL insurance has been compulsory, but we don't know who it is. But it's somebody on, for want of a better expression, that side of the room, insofar as they're representing the liability insurance industry, and not the state. And in many cases, it will be Aviva. So the swings and roundabouts, if there's complete missing insurance, they don't pay anything, and the state picks it all up. But we say that's part and parcel of a process of legislative compromise.
NHS payments are not covered under this scheme, are they? So they are in a very minor amount, under Road Traffic Act, but
Yes.
they're not picked up here. And it's well known that, for obvious reasons, industrial disease cases can be very expensive to the
Yes.
NHS.
Exactly. So that, a yet further point, and we'll see it in the evidence, is that we are only looking at a modest contribution, and we've set out in our skeleton argument, and it will be well known to the court, the consequences of personal injury go far beyond social security payments. We've listed them out. I mean, the state loses the benefit of an economic taxpayer, in some cases, not all. If they're retired, I accept that. State's got to pay it up. There can be diversion of another taxpayer into caring, and so the state loses the benefit of that person.
When compensation is made for loss of earnings, it's made on a net basis rather than on a tax basis.
Yes, indeed. So there's a revenue shortfall arising from the tort, possibly well beyond the individual victim. There's state expenditure in terms of welfare, not just limited to these benefits. The state expenditure in terms of healthcare costs. And there is
Next to these victims, that's going to be a really substantial liability of the state, isn't it?
Yes.
The healthcare costs.
Yes, absolutely so. So all of those very
None of that's covered here.
none of that's covered here, and even aspects which can't be measured economically. So the disruption and damage caused to society by industrial injury. And part of the mischief that's identified in the very lengthy history is about hidden subsidy, and let's make it more difficult for these torts to actually be perpetrated, make it financially complex and problematic for industry, because that will incentivise them to sort it out.
Well,
It's not just about...
That's part of the thinking going back to the foundation of the welfare state, isn't it?
Yes, absolutely. It is about...
In fact, it had started before then, in
Yes.
a sense, because the first Workers' Compensation Acts were earlier than that. But it was part of the overall thinking that if you impose liability on employers and their insurers, then what you should get is improved working conditions.
Indeed, it's about using legislation as an engine of social change. And we say that that has not been appreciated, and with the greatest respect to Lord Manson, the Welsh Bill case was not properly appreciated there either. That this isn't just about economics and a notional state insurance system. And the way the insurers put it, unsurprisingly because they're insurers, is that, well, you've had your tax and your national insurance, and that's your premium, and therefore you pay out when the risk materialises. But the welfare state is not based on that model, and never has been. It's about using social policy as a vehicle for change, and recovering benefits, and frankly, imposing liabilities is a means of doing that. So the disagreement that we have with one of the ways it's put by the judge and by the insurers is that they say the true costs of the tort are the matching costs, whereas we say no, the true costs of the tort are far wider. That's the actual legislation. I wonder if it's helpful just to show the court very briefly the supplemental bundle at tab 8, because what you have there is the insurer's own act.
Possible rewording.
Yes. below, as reflected in that document, it didn't really appear to be limited to existing policies.
Supplemental bundle tab
Yes,
8.
tab 8, page 39, my lord.
Struggling with my bundles, but I'll get there. Should have an electronically, shouldn't I? Tab 8.
My lord. So what one has there is the insurers coming along with an act of Parliament, which Parliament has got no interest in. So our first point is, well, they've got no business coming along and saying what they would like the law to be. So it is revealing that they say that this is what Parliament has to do, which is essentially, what they describe as possible rewording. What the insurers are really saying is, you Parliament need to go back and do the job again and do it in the way that we're dictating to you. Perhaps I'm overstating it slightly, but
Well, they're just saying that it's unlawful under the Human Rights Act to have it in its current form.
Well-
I don't think we're a jury. Let's
lord.
get on with the wording.
my lord. Well, we say it is revealing because it does go to some extent to remedy that they come along and say, well, this is what you've got to do. Our point is really this: if there's going to be a change to the legislation, and if the insurers think there's a compelling social reason for it, they do what anyone else in society does, which is complain to Parliament about it, and then Parliament will think about it and decide. And the fact that they have failed in the past 25 years to persuade Parliament doesn't mean that there's any basis for coming along to the administrative court and saying, well, we'll do it through this route instead. So,
But it goes back to the point my lady made to you a little while ago about Section 3 of the Compensation Act, doesn't it?
yes,
That Parliament had an opportunity in 2006 to consider all these matters. And for that matter, insurers had an opportunity at that time to lobby Parliament to consider it.
the insurers have no shortage of lobbying power, as one sees in all of the legislative history, not just this
Take
measure.
judicial notice of that, Mr. Brown.
Yes, so they are well equipped, and they haven't got it. And there's a point here, it's a point identified in Countryside Alliance, cases such as that, have to be careful. They failed in Parliament to limit their liabilities, which in fact they did here, then that is one of a number of factors, which means that the court should be rather circumspect on giving them what they want through the judicial process. I'm proposing now then just to deal with the Bainbridge case.
Yeah.
So he is a victim of mesothelioma. His particulars of claim are in the supplemental bundle at tab 23. And they plead out, see paragraph 45 in particular, a common law personal injury claim for negligence and breach of statutory duty. And we see that in this particular case, he was 77 at the time, see paragraph 8 of particulars of claim, and he was in fact retired. Of course, you inevitably have to be retired at 77 or indeed any age.
So what paragraph are we on?
That's paragraph 8 is that, sorry, the age is at the end actually in the schedule of rules. So, give me, 484. Yes, so particulars of injury, 484. He's 70.
Yeah. Yeah.
And do we know what his current position is on it?
No, my lord. Well, I don't. The defendant is a named defendant, Markup Trading Limited, which is the successor entitled to the entity for whom Mr. Bainbridge worked between 1976 and 1993. And then one has to cross-refer this to the HMRC Schedule of Employment, which is behind tab 22. At page 474. So, one looks at this, one sees that Mr. Bainbridge worked for Malins Leeds Limited from 1962 to 1968-69. But that is a missing employer.
Yeah.
And then there is also what the insurers describe as a gap in traceable insurance coverage between 1976 and 78. So we know who he worked for, but we can't find the policy.
Right.
And that, of course, postdates 1972 when EL insurance became compulsory. So assuming compliance with that, we know that there is a policy out there somewhere. Now, what Mr. Bainbridge tells us in his witness statement, which is at tab 21, is that he was exposed to asbestos in the period from 1956 to 68, and then again from 1976 to the 1990s. So that's the temporal period of exposure. And that founds then the pro-rating at common law. So there's two sets of pro-rating that one needs to do to get it to the 35.3% figure. The first is, what is the temporal period of exposure generally? And the second is, what amount of that is attributable to a policy which I am the insurer for? And in simple terms then, Aviva's prorated liability is 35.3% of the whole. Although there were, in fact, Swiss Re and one other appeared to have made payments, so it might be that some other insurer. But for simple purposes, it's a liability of 35.3% on the part of Aviva, and that liability is discharged by Swiss Re. So what one doesn't at common law prorate Mr. Bainbridge's damages claim, because he's claiming for mesothelioma, and the 35.3% adequate liability principle has been reversed by Section 3.
Reversed by Section 3.
Yes. So that's all then reflected in the consent order behind tab 24. So one sees then that Mr. Bainbridge gets judgment for £170,000 for damages in respect of all heads of loss, excluding the costs of future medical treatment. And then 2B is the important part for our purposes. So that the parties, as they're entitled to do, treat then the liability to the compensation recovery unit accrue is a liability of the defendant. So first of all, the order calculates what the liability is. And it's £22,786.35 and references the benefits there. And that is the statutory credit provided for in Section 8 of the Act. But that applies only to the PWCA payment. So that's a Section 1A payment for the lump sum under the Pneumoconiosis Act, and the attendance allowance. So that's part 2 of
The IIDB element is not included.
No, so there can't be a credit under IIDB.
Because he didn't claim it.
Exactly.
Didn't claim loss of earnings.
Didn't claim loss of earnings because he didn't have any. So the credit arises by reference only to the PWCA payment and the attendance allowance, and his damages then are reduced. That prevents him from being doubly compensated in respect of that. And IIDB, there's no reduction for the reasons my Lord has just set out.
Well, there couldn't be any complaint about the PWCA or attendance allowance payment.
Well, it doesn't matter
Because they were liable for the, if they hadn't got the credit, they would have been liable for the damages anyway.
They cancel each other out.
Yeah.
So the point here in the complaint is that they say, well, in respect of the benefit, why should we be liable for the additional amount, IIDB? That's their cross appeal. But they also say, well, why should we be liable for anything beyond 35.3%? Because at common law we're not. So why, state, are you holding us liable for 100% of those benefits, when at common law, leaving aside section 3, we're only liable for an aliquot share of damages?
Speaking for myself, I don't understand how that argument works in circumstances where their actual liability to the victim is 100% because of the act.
It doesn't even matter anyway, because what the common law is up to is not what the statute
Well, I
is up
understand
to.
that point. I mean, they're
Yes.
two separate points, really. I mean, one is that point.
Yes.
The other is it doesn't actually represent what they would have been liable
No.
for.
Because
That's what they're trying to do, is to match what they're actually liable for to the victim in
Legally,
some way.
yes.
well, not legally.
Legally liable.
No, at English common law, because legally they're liable for 100%.
It's an
Yes, that's
artificial
right.
construct, though, isn't it? Because 35.3% limited liability has gone since 2006.
Yes.
Yeah, okay.
So this is why we say, well, where does this all come from? Well, where in the convention does it say you've got to match English common law, even when English common law is not fit for purpose? So if one looks then at the crew certificate, just to see all of this, that's behind tab 10. So one sees there the three benefits.
This is the,
Does my lord have that?
yeah, I think I've seen it somewhere else as well. Maybe it's elsewhere at the end of the bundle or something. Okay, well this is the certificate, is it?
Yeah, so what happens then is that compensated insurer knows it's about to pay under the consent order, but because of the Act, it can't pay until it's got a certificate. So it applies to the DWP for a certificate, and it's sent the certificate, and it can use that then to quantify how much it needs to pay the state. So one sees then the three benefits and how they're all quantified. And on the second page, Swiss Re paid on the 8th of April 2019. So if one looks at the third row on the second page, one sees that the liability to the state on that date is £39,232.15.
Sorry, can you give me the date again?
Yes, it's the 8th of April 2019. So what Swiss Re does is it looks at the certificate, says, right, I'm going to pay on the 8th of April. Third row on the second page, entry on the 8th of April, that's the liability to the state.
39,232.15.
Yes, but as we've seen from the order, it can apply a credit in the damages award, so it can reduce the damages award payable to Mr. Bainbridge in the amount of £22,786.35.
Did Mr. Bainbridge continue to receive benefits, or did the payment of the compromise mean that he went outside limits?
Well, that's a question, and we don't know on his facts, but he's had a very substantial lump sum payment, which is largely going to be taken into account for the purposes of benefits, but not inevitably, because not all benefits depend on your capital.
And well-advised claimants quite often devise ways in which perfectly legally benefits are not affected. But I mean, we don't know what happened in Mr. Bainbridge's case, but if they continue to be paid, then the state is out of credit, at least insofar as PWCA, well, that's all gone, but the other benefit is came, which was
Attendance allowance and IIDB.
attendance allowance, yeah.
Yes, so IIDB will continue to be paid subject to points about capital and things like that.
Yeah.
PWCA, once it's saw in the consent order,
Yeah.
he can come back for more in terms of care costs, so there will be further issues that might arise there.
Well, that's a capped payment. If you look at the certificate, it doesn't change.
Yes.
But IIDB and AA may continue, and AA, the insurers might have been continually liable for.
Yes, so one can have interim payment situations, of course, in complex personal injury, which all then feed into the certificate. But in very broad brush terms, what happens to Mr. Bainbridge, though, is that as soon as they pay on this certificate, they, subject to the point about further care costs, they walk away. And they do walk away from the liability to the state. And then it will be a case-by-case assessment in terms of what other social security entitlements Mr. Bainbridge has in light of his damages and his other resources, and having regard to the provisions of those benefits.
But we don't know the details of that.
We don't know, no. What I would say is that across the cohort of the whole population, there will be people who continue to receive social security, of course, and other costs.
Can you just help me, please, with page 1 of the crew certificate? So this is the page 42 of the bundle. This is the document that the insurer completes when he sends the money in. He or she sends the money in. Do you see the references to if NHS charges are applicable, a NHS certificate will follow, and then in the box just above the signature box, NHS charges where the date of incident is on or after the 29th of January. As part of the settlement, a finding of contributory negligence was made which reduced the compensation payment by. Can you just help me with those two entries?
Well, I can only help my lady to a certain extent because I don't have the detail. I can provide it, of course. It is right that there is some provision for recovery of NHS payment, and it is also right that there is...
road traffic accidents, is it?
Well, I can't confidently say now what the full scope of it is, but I do accept it has some consideration of contribution. It's not part of my case that it is impossible to take into account contributory negligence.
It looks as there's a deliberate decision, is my point, that there must be another statutory scheme or some sort of regulations dealing with NHS charges brought in at some stage in
29th of January 2007. I mean, it looks as if this first page covers everything, including injuries in road traffic accidents. And then what we get at the second page, page 43, is the first page of the actual certificate.
Yes.
That relates to Mr. Bainbridge, which doesn't include NHS.
But it looks at whatever scheme there is for NHS charges, there may be a reduction or a pro rata adjustment for contrib.
And it's also incidents after the 29th of January 2007, which won't cover
Lord,
those.
my lady, if I can assist,
Yes,
the relevant legislation excludes diseases, so it's for every other injury.
So every
it's
other
recovery of
just straightforward injury. Thank you very much.
Yeah. So this is to do with injuries, not to do with.
Yes, it was a
industrial
decision
disease.
of we rely upon that, of course. That
Right,
the
okay. Now I follow that point.
excluding
Mr. Bainbridge.
different
Thank you very much.
And it may be I'm being a bit defensive or anticipating a point that's not being put to me, but as it's indicated, about contribution, contributory negligence, it's not beyond the wit of Parliament to do that. Of course, it can be done, but that's a completely different matter from looking at what Parliament has in fact done, which is really what we should have been reviewing.
I understand your point.
Yeah, and I accept that it's not unreasonable necessarily to test the scheme by reference to possible alternatives. That's often a good way, a rationality challenge of looking at what in fact decision has been made. But here, they're actually mandating it in circumstances where Parliament said, no, we're not interested in it. If it would be helpful, my clients who obviously know this inside out can provide the court with the detail on the NHS analogous provisions. We can do that by way of supplemental.
Well, it might be helpful because Mr. Kent's obviously going to make some play of the fact that that did address contributory negligence. It would be quite helpful to understand. I mean, you've got the point which you just made that Parliament thought about this and decided against it.
Yes. No. Not only is that apparent from the Act, the statute, it's also actually apparent if it's relevant from Hansard.
Yeah.
But we'll come on to that. So that certificate then terminates Swiss Re's liability, generally speaking. And thereafter, as my lord indicated, that then the social security regime itself, so the position as between the state and the victim or the individual, that occupies the entirety of the field, as it were, and those rules take over. So this was what the insurers describe as a long tail claim. So the policy was some years ago, but it is still a policy for which Aviva has received the benefit of premium.
But what we don't know, if you go to page 46, we've got a breakdown of the benefits which show that for example, and obviously the lump sum payment was a lump sum payment, but the attendance allowances for the period between the 29th of May 2017 and the 29th of May 2019. We don't know what the position was before 2017 or what the position was after May 2019.
No, we don't, because the scheme makes it irrelevant. So it starts the claim on the date of the claim by the claimant in general terms, and then it's 5 years from thereafter. So pre-existing payments are not caught either.
Claim for benefit, not the claim.
Sorry.
I think it's the claim for benefit.
So I've misspoke. So the claim for benefit then, so I'm grateful. So what this would tend to suggest then is that the claim for benefit has been commenced on that date in 2017.
Well, that's rather what I assumed.
Yes. So what happened before in terms of benefits? Well, there might have been other benefits, but not listed ones.
Okay. Well, one suspects that he'd been paid benefits before then because he'd been ill for quite a long time, hadn't he?
Well, he will have had benefits. Well,
And he hadn't worked for quite a while.
yes. Well, he would have had a state pension. What other benefits he may or may not have had may not be all that significant here.
Well, he first developed symptoms in March 2017, which is why the claim's from there,
Yes.
according to page 484.
Yes.
Thanks very much.
So we'll draw all that together in terms of when he starts. So that's the certificate. What does one do to that liability which has been established? Well, on the insurer's case, and arguably on the basis of the order, what one does then is a series of reductions to the amount stated in the certificate. So in situation 1, we reduce by reference to his notional contributory negligence. We don't know what that is. Don't know if he's a smoker, don't know if he wasn't using his PPE on the day or matters of that nature. So that's the first situation. Second, if it were an asbestosis claim, then because that's divisible, one following the contribution reduction presumably carries out another reduction to reduce it to the contribution amount, so the temporal period of exposure to asbestos. So if there's a missing tortfeasor or a missing insurer, here there are both, then the state steps in to meet that on the insurer's case. And then sections 2 and 3, situations 2 and 3 are in the alternative. So it's divisible or indivisible, but they arrive at the same conclusion, namely that situation 3, this case, meso, one does the same thing as under situation 2, because that's the common law position following Barker and Chorus. And then, if that weren't enough, you then reduce or take out the listed benefits in Schedule 2 which the insurers disagree with. So there's no universal credit claim here, but I understand that the gist is they want universal credit to be removed, even though that's the primary benefit now. And you also reduce or take out IIDB, because they say it's a bit tough that you don't get a credit for it, essentially. Then fifth situation, compromise. So they say, in their favour, as they would have it, well, the scheme also doesn't reflect the fact that there has been a compromise in Mr. Bainbridge's case, and it's theoretically possible that at common law there's no liability. So if there had been no liability at common law, so if they'd fought it and the tortfeasor had won, then there would never be a liability under Section 6 because there wouldn't be a paying party. And so why then is there a liability simply because they've agreed to compromise? However,
The Act says so.
The Act says so, yes.
Because the Act says that it applies in cases where there's a compromise or settlement.
That's what the Act says. But they do say, well, we are very generously not including that as part of our A1B1 complaint, but you, court, must factor that on our side of the balance, even though Parliament has done its own balancing exercise. That's the logic of situation 5. So the insurers say these are complaints at the margins of the scheme, but using the paradigm, the state gets nothing, which is not caught by the credit, as it were, or it's difficult to see how the state gets anything. We don't know, because they've not applied the calculations of the notional matching scheme to Mr. Bainbridge's case. But we do know that the starting point is 35.3% of the full amount. That's what they say is certainly a reduction that falls to be made. You then do compromise, you then do contrib. And then for good measure, you take out the benefits we don't like. So it does tend to suggest, but we don't know because we don't have any damages schedules, but they say that there is no liability. Now, we've got a section in our skeleton argument that says why now. So why are they bringing this to the court's attention in 2020? And they say, well, we've had very heavy claims exposure since 1997. Did Parliament really know what our book was going to turn out to reveal? To which we say, well, Parliament took a view. In fact, there's evidence of its evaluation of actual costs that would be visited on the liability insurance industry. But the claims exposure also moves with the exposure to the state as well. They go hand in hand. So more claims coming out means that the state's bearing more costs. So the social balance compromise that's set out in the 1997 Act moves alongside the developments in the law and the market developments in terms of number of claims that are being revealed. So the taxpayer continues to recover in its interest. And as to the point of, well, it's not just claims exposure, it's claims exposure plus Fairchild, Barker, Section 3, and all that on top. Now this is really becoming too onerous for us. We say, well, Parliament knows all of that. What you don't have is any sense, because the insurance have led no evidence, as to what this actually means in terms of interference financially. This is a financial claim fundamentally. And part of the A1P1 balance does require one to actually look at the individual effect. So if their complaint is the tipping point has been reached and the burden is one we can no longer shoulder, then they need to tell us why that is so, having regard to their position. But they haven't.
We've got, I think,
Yes.
evidence about how the scheme works in practice from their side. We just have no figures in relation to the claimants. Is that right?
We have no figures in relation to the claimants. So we know there are additional liabilities. Everyone knows that. Parliament knew that. That's the whole point of it. So we know that there are liabilities that are properly measured in the tens of millions of pounds. The insurers tell us, well, we've got lots more claims, but we say, well, you have premium for all of those. So insofar as you've got more claims, that's partly your own issue to deal with. But insofar as you haven't had premium, because there's an imposition of further liabilities, then that's the way it goes. This is a balance between the interests of others and insurers.
So is the closest we get evidentially to Mr. Donovan's statement?
Probably. And we-
Probably, because Mr. Bashford doesn't really deal with this, so it's going to be.
Mr. Towers has a bit about the net amounts of recovery, which gives an indication of what the state's recovering from the liability insurance industry, generally speaking. So we know that the sector is bearing a burden which is probably measurable in the tens of millions. And they are properly described as additional costs. But human rights are, of course, individual rights, and one has to look at particular burdens. Because if the legislation hypothetically said we're going to levy a £1 charge on every policy, then it would be inconceivable that Swiss Re, as the largest insurer in the world, or one of, would come along and say that that's an unreasonable interference. You might not like it, but the quantum has to be something which tips the balance, and indeed that's how they put it.
So I just can't find the bit in Mr. Towers where he talks about a statement where he talks about tens of millions of pounds additional costs. Have you got at some stage reference to the paragraph
Yes.
you're referring to? Thank you.
If I may return to that, we're going to look at it in the judgment. I'm going to go to the judgment now, and there's some consideration of the evidence in the context of that. It might be my recollection of this being in Mr. Towers is mistaken, and in fact it's in the insurer's evidence. But
It's paragraph 45, unclear as to what additional liabilities insurers are asking should be met by the
Tens of
state.
millions pounds.
Appears
Yes.
to be in the region of £10 million annually.
yeah, I think there is a bit.
A, I think.
Yes.
Yeah, 45, so. Oh yes, you're quite right, yes. Quite right, yes, 41A.
I think we've got a bit more. Certainly that it is interesting, we say, insofar as you can look at Hansard, that points he's making, they come directly after all of the actual specific points debated in the House of Lords, which are actually talking about numbers, and they're saying, well, we think it's going to be around £71 million a year that you, insurance industry, are just going to have to live with. Cost of business, basically. You're not going to be able to pass it on because these policies exist. You're going to have to pay. And we say, and the judge disagreed, that actually, if it's relevant, Parliament probably got it about right, but I'll deal with that later. So the projected numbers are basically what they are, in fact, bearing. But it doesn't matter. I mean, Parliament could have got it completely wrong. It's still today, on the always speaking principle, of the view that this is the right balance. And if, to repeat the point, if it is so overwhelmingly clear that this has become unreasonable, then take it to Parliament to see what they say about all of it. What I'm proposing to do now is to take the court to the judgment. I'm proposing to use the law report version. My lord has the other version, that's fine. It might be my page numbering is
It's your paragraph numbers,
fine.
only because it's easier finding it at the end of it.
So, starting at the beginning, the way that the issue is encapsulated by the court is that my client has interpreted the Act in a particular way. So, see paragraph 1. So, true it is, it's recording the contention of the insurers that the Secretary of State has interpreted the Act in a way which is objectionable. But, in fact, there is no dispute that, leaving aside the Human Rights Act, the correct interpretation is the interpretation that I've taken the court through. What the statute says is clear. So it's not my client's unreasonable and irrational and erroneous way of reading the statute that's really criticised, is what the actual Act says. Paragraph 2 records the fact that a scheme allowing for recovery of expenditure by the state does not in general terms violate convention rights. So the starting point for this claim is that a state can indeed levy contributions, as they're called, under A1P1, in addition to taxes. And contributions sit next to taxes in the structure of A1P1, as we'll see in a moment. And it appears to be accepted in paragraph 2 that a matching rationale is not mandated by the European Convention on Human Rights. So you don't have to have a matching rationale in order to have a notional match between what they say is their responsibility and what's fair for them to pay in terms of a statutory liability. Then paragraph 3, just to see how it's put here, they say the aspects which the claimants do challenge relate to what they describe as an unintended but increasingly onerous byproduct. And the word unintended is important here because it doesn't mean unintended in the legal sense, i.e. it's not the intention of the statute. It means unintended in some other sense, a non-legal sense, meaning is not what the 1997 lawmakers in fact had in mind. This is a theme which runs throughout this judgment, is that the judge perceives there to be some difference between the intention as a matter of law, which is the intention of the Act, always speaking today, and what the 1997 lawmakers were up to back then, which is something that the court has determined as a matter of fact. And paragraph 6 of the judgment records that the claim succeeds in part on the basis that, in summary, to the extent that it requires payments to the state which, in summary, do not correspond to the insured's real contribution to the injury, it fails to strike a fair balance between the rights of the state and those of the claimants and is incompatible with A1P1. So, in a sense, the court has slightly pulled its punches because it says do not correspond. That doesn't go far enough because there is some correspondence. The insurance complaint is they don't match precisely the common law. And then the second point there is which we would respectfully criticise, is the insured's real contribution to the injury. Well, that's fine as far as it goes, but even then we will probably quibble, because the real contribution, we say, both to the injury and to society, is much wider than the damages amount as calculated at common law.
But it's there that the failure to take into account NHS treatment, etc., is immediately obvious. I mean, it's not recoverable because it's provided by the state. He could have opted for private treatment but doesn't have it, and there's no real private treatment for this available anyway.
Yes. There's points of principle. My lord is right. There could be private healthcare. In fact, Lord Mance considers this in very cursory terms in the Welshmill case, where he says, well, people generally don't for this sort of injury. And I think that might be the same point that my lord's making to me, but it doesn't matter because the availability of private or state healthcare is simply one other aspect of expenditure. The deprivation of the economically active taxpayer is a very profound one, and which is very difficult to measure, and is one which the state can reasonably have in mind. The diversion of another taxpayer into carrying all of those points, they're dealt with by Parliament as one would expect Parliament to do, namely the value level. It's deciding what the relevance or relative significance of all of those points in fact is, and it's striking the balance between them all. And it's not intended to be economic, well, you're getting this on that side, and therefore you get an equivalent benefit on the other side, because that's not how Parliament approaches social policy of this nature.
But it must be relevant to consider, in my lord's point, really, that what it is that the state itself bears, it doesn't recover from anybody.
Absolutely so.
In this context, other than from taxpayers.
Yes, so we accept there is fives for a rationality or an A1P1 challenge which requires a consideration of proportionality and fair balance. And it feeds in a fair balance in a far more significant way.
So if you were looking at the difficulty is, it's not really the insured's real contribution to the injury that he's comparing with, is he? What he's really comparing with is the insured's liability to the victim,
Yes.
legal liability to the victim.
Yes.
If you take contribute as the obvious example.
Yes.
But what it doesn't address at all is the insured's real contribution to the injury in terms of the social implications of having negligently caused an accident which led to Mr. Bainbridge having Mr. Leoma or whatever it was.
Exactly so. So it is trying to put into financial terms something which the state thinks is difficult to do, because a lot of this is non-financial, and in any event has declined to do. It's adopted a scheme which intends to meet all of the points that my lord makes. So what about the wider consequences? Using this, and indeed other measures. So this is one way of furthering the social policy. We refer it almost in passing, as an argument, to the fact that it also legislates in terms of health and safety reforms and things like that. It's part of a suite of measures that one has to respond to the fairly naked position of the common law, which doesn't really deal with any of this, both as a matter of health and safety law or as a matter of benefits and those aspects. So the common law has long been recognised since Beveridge as not being fit for purpose here because of the evolution dating back before Beveridge, the principles of damages that go back to the mid-19th century and how they interact with payments from third parties and things like that. So
The concept of common employment, which was
there was all sorts of
to be
mischiefs.
remedied by statute,
Yes,
which was pretty pernicious.
yes. The position at common law for a victim of an industrial injury has always been unsatisfactory, and there's always been reaction, not just from Parliament, but also from the Supreme Court and the House of Lords. In some cases, it's furthered the mischief in the courts, and let's see Section 3 in response to that, and many other examples going back to the 19th century of when the House of Lords has struck a balance which Parliament thinks is not fair. And Parliament recasts the balance, because that's what Parliament does. So Section 7 then sets out the summary. And Section 8 then summarises the scheme and the complaint in respect of listed benefits, so the situation for the cross appeal.
When you were saying section, you mean paragraph?
Sorry.
Yeah, no, I just want to make sure that
Yes.
I'm following you.
Paragraph 8, yes. And paragraph 9 records the far-reaching changes in the law since 1997. So those changes have impacted on the balance for good and bad. And the final sentence of paragraph 9 makes a point, restates revealing how the judge puts it, that these changes have the consequence of increasing the amount the defendant considers she is entitled to recoup. Well, she doesn't. She is obliged to recoup them because that's what the Act says. There's no discretion here. And paragraph 10 summarises, and we have no complaint about it, the summary that's in McGregor about the various twists and turns of the common law and statute. And our point is the Parliament knows about all of that. In paragraph 11, the matching complaint in the 5 situations, and I've taken the court through all of those. In paragraph 12, they say, well, you can read down, and we'll come on to reading down. And there's the first reference to Lord Mance in the Welsh Bill case. And I accept, of course, that it may well be that were it not for Lord Mance's overture judgment in that case, we might not even be here. But he has set out a view, a fairly trenchant one, which is to the effect that if there's a contract, you can't interfere with it. Because it...
I didn't read the whole of the judgment. I only read those bits of it that you invited us to look at, which is quite a lot of it. Does Lord Mance anywhere refer to the 1997 Act?
No, he doesn't. It's interesting because it is odd that
Nobody seems to. I know it's a sort of Welsh-centric
Yes.
piece of litigation in the sense that it was actually quite interesting, isn't it? Because it's not really litigation in a true sense, because it's actually the Welsh government represented by the General Counsel on the one hand, and then I think the ABI intervening.
Yes.
So you don't get potentially a full range of argument, I suppose. So,
What you don't have is any evidence, really, of a particular policy that would justify the interference. So, nothing is revealed in Lord Mance's judgment about an evidential case and a legal argument similar to that which I advanced before the court below, which is, well, this is why, notwithstanding all of that, we still are of the view that this is a justifiable interference. Lord Mance effectively takes the position that if it's retrospective, it can't be justified. But what that means is, in the context of insurance, that there is no interference prospectively. The insurers now accept that. So it's always going to be looking backwards that the question of interference with A1P1 even arises in the context of an insurance contract. Because if it's an insurance contract that incepts after the measure comes into force, they're going into it with their eyes open. That's our position, as we say, in relation to Swiss Re. So,
but also that case concerned a piece of legislation being passed by the Welsh Assembly.
yes,
In circumstances where there was an issue as to its jurisdiction or its power or whatever
yes,
to do so, which couldn't begin to be reflected in relation to any consideration of this piece of legislation of the UK Parliament.
yes, that is glossed in this judgment. The act with which this court is concerned is an act of the United Kingdom Parliament. And that is something to which Article 9 of the Bill of Rights applies, but in any event, it is the United Kingdom Parliament, and the margin in relation to a primary legislation of the UK Parliament will potentially be different as against that of a devolved assembly. So I have a number of points about the Welsh Bill case. The main point is that it's obiter, so you don't need to be concerned about it. You can respectfully disagree with it. But on proper consideration, it's wrong, and in any event appears to be based on a very different set of arguments from those which we were advancing to this court.
Can you just help me on a piece of different tack on how it only emerged after the main judgment that the claim was limited to pre-March 1997 policies, and did the open-ended nature of the debate before that concession, or did that affect the judge's thinking or the arguments in any way that might be relevant for us?
Well, the judge says in his supplemental judgment he always
I understood
appreciated.
that to be the case, yes.
But my complaint was, well, I showed the court their proposed wording and the arguments that advanced before. It certainly wasn't clear, and maybe this was always their case,
I see.
that they were limiting it only to existing policies. Because the matching logic applies prospectively and retrospectively. If they're saying that under A1P1 you've got to have a matching scheme corresponding to common law, why does that not apply going forward as well? There's no sensible answer to that. Because they say it's mandated, it has to be a matching scheme. What they now say is that, well, going forward you can do what you like, but going backwards you have to have a matching scheme, which is a far more limited argument, and of course we'll take that.
And that point ties in with the point which you told me, and which is the point about the judge's rejection of their condition 4, or whatever you describe it as, and leave 5 out of the matter.
Yeah.
But there's a complete lack of logic, really, in saying, well, 1 to 3 can be struck down as an unlawful interference under A1P1, but 4 stands.
Exactly.
Because 4 is a sort of, you might have thought the argument would be 4 is worse than the other 3.
Yeah.
Because 4 is the point about, your point about IIDB, isn't it?
Yes.
It's the point that it's paid out and the insurers are liable to reimburse, even though there's no claim for it by the victim.
But if one takes
No
4,
claim for loss of earnings, that is.
my lord, I absolutely agree. And if one takes 4, why doesn't one take 5 And then why are there not actually situations 6 through to 10 where there are other aspects of the common law which might tinker with damages? Why do we not bring all of those into account? And what one has is the insurer's shopping list, where they say, well, 1, 2 and 3 we don't like, 4 we also don't like, 5 we'll live with, and the rest of it we'll save for another day, or we'll live with, we don't know. And it's a curious way to present a challenge of this nature, given that it is premised solely on what is said to be inevitable consequences of A1P1, namely that they mandate some sort of fault-based matching scheme. But then they don't, because they don't apply going forward at all, and then one carves out certain situations in which they also don't apply. So where does one get this from? Where is it in the Strasbourg case law or any other case law? That is why we describe it as being the insurer's own creation, which it is. And to impose that on a sovereign parliament because they say it's fair is really a heavy task. Then 13 to 14, court records the fact of rise of claims. May well be right, Parliament knows all of that. We say that's had a devastating impact on society, and therefore the fair balance is not affected. And 15, we'll see the insurer's complaints then. And again, the formulation of the language that's used by the judge is adopting this idea about fault and wrongdoing, and there being some notional correspondence with the statutory liability to fee-paid benefits and fault at common law.
Sorry, where are you?
So 15, the claimants accept that it's proportionate for them to be required to pay for benefits which correspond to damages for losses which their insurer caused, but complain about their obligation which corresponds to damages for losses not caused by their insured or in respect of which there was no corresponding kind of loss. And then there's reasons given for all of that. So just very briefly, 15 Roman 1. They say they're required to pay very significant amounts of benefits even when these are not the result of their insured's wrongdoing. Now, state benefits don't work like that. They don't work on the basis of fault. They're just payable at the point of need. That's what Beveridge says. So the connection between responsibility at common law for benefits and the payment of those benefits is a very tenuous one in any event. So we say that...
Well, that's presumably why IIDB is payable and paid even when there is no loss of earnings.
Yes, absolutely so.
It's actually got nothing to do with what heads of loss might be recoverable at common law.
Yes, that is right. It's a particular benefit that has its own particular criteria in very limited circumstances, which basically gives an additional benefit for victims of very particular industrial injuries. And that's Parliament's view about what's fair for those victims. So it's created that benefit. It's payable at the point of need, and that's irrespective of the tort. So the equivalence or connection...
That was brought in by statute in 1992, is that right? Brought in by the Social Security.
Well, that's a consolidating statute, so it probably exists.
Probably antedated.
Yes.
Lord Hope's point in AXA was that it's wrong to say that they're required to pay damages even when they're not a result of the insured's wrongdoing. True, it is not as a result of common law damages that you can claim, but there wouldn't have been any benefits claimed if the insured hadn't been negligent, and the insurer would then have been liable to pay.
Not necessarily, because the accident is not an inevitable consequence of negligence. So in most industrial accident cases, then one will establish negligence, but not inevitably.
No, but I don't mean negligence or breach of statutory duty, but there's fault. The insured's wrongdoing. Otherwise, they're not paying anything. They're not going to pay to a claimant and therefore trigger their liability under Section 6 unless they've been at fault.
Well, they may compromise. They may say we've got a compelling case, a compelling defence here on the particular facts, because in fact we took all reasonable steps.
Fine.
Yeah.
Then the point, though, and this, again, the point I've been emphasising, they say never been considered by Parliament. Well, query, we'll have what we say is an appropriate look at Hansard, not proposing to take this court through reams of legislative material, because the Supreme Court in SC says you don't do that.
No.
But in any event, it's not about what Parliament's factored into its balance, it's the output, it's the act that matters. And then no justification for it. Well, again, we say there's a problem here in the way that the court's gone about this, because we have a clear justification argument. It's set out in the evidence and the detailed grounds. And true it is that the reason why the state justifies what the Act does now may well be different from what the lawmakers had in mind in 1997, but that's not objectionable. You consider the matter as it stands today. The times have moved on. The state is still of the view, as expressed by the Secretary of State, that there are very clear and overwhelming good reasons for this measure, irrespective of what the parliamentarians might have had in mind. And again, that's the point that's dealt with by SC. It doesn't matter what the government's saying at the time or what the parliamentarians were saying at the time. The quality of their debate may have been very poor indeed. It wasn't here. But that's not a relevant consideration.
I mean, all the judge is doing here is summarising
He
the
is,
answer.
yes, but he does in fact accept most of this, so it's a convenient way just to see it all. And retrospective effect, so it's exacerbated by the fact that the legislation is retroactive. In fact, in truth, it's not exacerbated, but that is the complaint, certainly now, because it's conceded that prospectively this is all absolutely fine.
But it is true, isn't it, that they cut, and I think this is dealt with by Mr. Donald,
Yeah.
that because of the retrospective nature of the legislation, they can't, in fact, claw back additional premiums,
Yes.
because to do so would make them uncompetitive in the EL market.
So they can't pass on, but if
So they can't pass it on.
yes, but if they passed it on, there wouldn't be an A1P1 breach.
No, I understand that point, but I mean, that's
Yes.
part of their argument.
Well, it's difficult
can't
because
pass it on.
they accept that the state can interfere with contracts, and everybody accepts that in principle. But the passing on situation means that actually there's not even an interference in the first place. So we're in a territory whereby we've all agreed that the state can interfere with existing contracts, as it has done. What that means then is doing so disadvantageously to the insurers here, meaning that it's doing so in a way that can't be passed on to customers. So the insurers have to bear the cost themselves. And therefore, it is that which triggers the interference with A1P1, the fact that they have to bear the cost, and some of it will not be capable of being passed on. Some of it will, in which case no A1P1 breach. Some of it won't, in which case it's an overhead, it's a cost of business, and it's coming out of their resources. And there we are. The Parliament knew that. It knew what it was doing. It knew that it was looking to a liability industry, insurance industry, that could shoulder those costs. Then, very briefly, Roman 3, just to summarise the arguments which are ultimately accepted. Insurers say in court held, do not strike a fair balance because then A, 97 Act does not correct a social injustice as between tortfeasor and victim, but rather involves recoupment of state benefits by the defendant and in many cases works against victims. The second part of that, I mean, I've addressed the court in some detail about why it is social legislation. But they say works against victims, that's part of the insurance evidence that there are some situations when, in fact, you're causing problems for the victims. But again, Parliament knows all of that.
Well, the victims took it all the way to the European Court of Human Rights.
They did, yes. So that's all known. Parliament's still of the view as expressed in the statute. The 97 Act does not build on established legal principles. Query what that means, because it restates the 1989 Act. So to that extent, it's building on established legal principles. And it reforms and develops principles that have gone back many, many years. But there is only one legal principle that's relevant here, and that is that Parliament can do whatever it considers to be appropriate.
I'm not sure I understand B, actually.
Well, it's taken
Because
from
the second sentence, it seems to be looking at the position as it is now, and seems to be saying, well, Parliament hasn't considered what the impact, or sorry, the Secretary of State hasn't considered what the impact is of all these developments in the law in circumstances where they may have been intended to benefit the victims of tort, but they have other effects.
Yes, the way the insurers put it is that, broadly speaking, the ebb and flow of the common law and parliamentary responses have been designed more to benefit victims and preserve awards of damages. That's fine as far as it goes, but that's very narrow because that's only looking at common law calculation of damages principles. Whereas this scheme is not particularly interested in those principles at all. And this idea that my clients had the advantages of the emergence of all of these liabilities, which he is now seeking to recoup.
Your answer to that is that the Secretary of State, the taxpayer ends up paying more in real terms as a consequence of these larger mesothelioma and asbestosis claims.
Yeah, so there's 2 points. First is
not recouped from insurers.
yes. The first point is she's had to spend more on social security in the first place, and the second point is, well, in addition to all the other points about other liabilities and impacts on the state. So it's not really properly described as an advantage that her expenditure has increased and therefore her recovery has increased, because the two go hand in hand. And insurers point C, insurers are not tort feasors, true, and therefore the policy considerations which underpin the concept that the tort feesor pays do not apply. Well, why not? That's the insurer's judgment as to what's fair, but the view of Parliament is very clear. We're going to impose liability on you both for good reason. One of the reasons being that we've intervened in this market, making EL insurance compulsory from 1972. That's to your benefit. Here you pay something back as part of the compromises of social and political life. And D, the point about mitigating, by which they mean not mitigating, but not actually bearing. Then 16, and the insurer is going to, I think, deal with some of this about how it's done elsewhere and what they would probably describe as more sophisticated legislative schemes that have been adopted since 1997. And again, I made my point, well, of course Parliament can do all of that. That's what it's decided to do in those cases. That doesn't mean it has to do something different by reference to the 1997 Act. It doesn't really take the matter very far, just to say that it's possible as a matter of legislative drafting to do a completely different thing. Of course it is. And then I'll deal with Welsh Bill later. Then position and outline. I don't need to repeat my submissions recorded in paragraph C, sorry, section C. Forgive me. And section D, legislative background. And I don't want to be unfair in terms of the criticism here, but this is a very skeletal summary of a lot of social policy history, and that isn't a criticism, because it would not be possible for the court properly to distill everything that's gone before. What the court really just needed to do was to recognise and acknowledge that this is a matter which arises in circumstances where there has been a debate going on for 70 years.
Why do you say 70 years? What's the
Well,
trigger date?
it really goes back to Beveridge.
Right.
We say actually the debate basically came
on for nearly 80 years, actually.
Yes, although we say that really the debate concluded in 1997 because Parliament expressed its will then and is not interested in the debate anymore. It's moved on to other things. So the debate's basically over as far as Parliament's concerned, subject to the Association of British Insurers lobbying them and all of that. But the reality is that this is a complex and nuanced matter with a range of reasonable views expressed over many decades, and that is an important matter when it comes to margin of appreciation. And with the greatest of respect, the court was never really going to be able to appreciate the nuances of the bargain following a 2-day judicial review hearing. Circumstances where select committees have debated it for years, evidence from all sorts of institutions and industry actors, and the court doesn't have the toolkit for this job. So that's fine as far as it goes, but it doesn't properly reveal the nuance because it cannot. And then paragraphs 26 onwards deal with predecessor legislation, and then there's a side issue which is dealt with at paragraph 30 about whether the statutory obligation under the 1989 Act could exceed the amount of the credit. I don't think anything turns on that. There's an argument about whether they could be in a position whereby the insurers basically have to pay a lot more to the state than they get by way of a credit. And we filed some supplemental evidence saying that the crew interpreted it in that way. Insurers said that was not right. And then the judge, I don't think as a matter of law, has determined it. It's not statutory interpretation because the statute's been repealed. So it's more like fact-finding as to what the point was in 1989. But it doesn't really matter because the fact that there was no correspondence, no matching scheme was part of the 1989 Act as well. So there's never been a matching scheme. What the insurers are really saying is that our quantum as a result of the actual scheme is just increased now. Then paragraph 34, background to the 97 Act. I'll very briefly deal with this, and that will give me a good launchpad for finishing or getting close to it after lunch. Paragraph 34 and 35 then deals with the background to the 1997 Act. At 35, the court accepts or states it's relevant to consider the reasons why Parliament chose to make a particular change. That's the changes in relation to the 1989 Act about there being an exclusion for small payments below £2,500 and no set off against general damages. And then the court takes our detailed grounds and says, well, they don't respond to these particular two tweaks of the 1997 Act. But what the court has failed to appreciate is that our case is that the 97 Act builds upon the principles of the 1989 Act, which create a direct liability to repay benefits.
Sorry, where does the judge criticise you for not dealing with these points?
So what the judge says at 35, say it's relevant to, and maybe I've taken this slightly too quickly, but the point at 35, when he refers to this change, what the judge is referring to there is the changes that remove the small payments exception.
I remember that, yes.
Yeah, and a general credit against general damages. The court says the true intent of the 97 Act was only to deal with those two situations.
Right.
That's basically what the judge is saying.
That's 36, is it?
Yes.
Why don't you come back to this at 2 o'clock?
Yes, ma'am. I will.